When conservatives on the Supreme Court gave new powers to corporations in the Hobby Lobby ruling, they said it would be a narrow decision. Do you know how long that lasted? About 3 days. Late last week, as the Independence Day weekend was about to begin and a lot of people weren't paying attention, the court issued a new emergency ruling restricting health coverage for women at Wheaton College. It was exactly the kind of expansion that conservatives on the court claimed the Hobby Lobby decision would avoid. A bait and switch so blatant and fast that Justice Sotomayor broke with the court's usual decorum to slam her conservative colleagues' dishonesty. Quote, "Those who are bound by our decisions usually believe they can take us at our word," she wrote. "Not so today. This action undermines confidence in this institution." Sotomayor was unusually blunt because the stakes are so high. Hobby Lobby did start out as a case about contraception, but the court's conservatives made it about corporations. And just as Citizens United helped rewrite the campaign playbook, businesses and conservative organizations are now lining up to use Hobby Lobby as a way to avoid following federal laws. The founders told us all men are created equal, but in this business-friendly court, you're often better off being a corporation with corporate personhood. And executives can avoid personal liability under corporate personhood for risks they take in the market. And now, with this new decision, under the new rights in Hobby Lobby, executives can basically pick which laws they don't want to follow simply because their company doesn't believe in them. If that sounds messed up, that's because it is. It may be a sweet deal for the 2% of Americans who run these kind of companies. But how long can the court put their priorities above everyone else? Joining me now in our rapid response panel, civil liberties attorney Burt Neuborne, who's argued a dozen cases before the Supreme Court and filed a brief against the expansion of corporate rights in the Hobby Lobby case, and Goldie Taylor, MSNBC contributor and columnist for The Griot. Good evening to you both.
How you doing?
Good evening, Ari.
I'm good. Good evening. Goldie, let me start with you. First on contraception, what we saw here late last week in capsule summary, as I mentioned, was something that looked much broader than we were told it would be in that original opinion from Justice Alito. Your thoughts on that and the politics of this expanding case?
Well, even before Wheaton, I believe that this was much more broad than Alito wrote in his brief. You know, I always believed that you could not write a decision narrow enough that it only would pertain to contraception, that once you gave a person the right to infer their values, religious or otherwise, onto a separate corporation, then there would be no end to that. And we saw it within the coming days just after that truth bore out. What happens, I'm going to wonder, when someone who is a non-Christian, a Muslim, for instance, decides that they want to impart their closely held religious values on a company that they own that is not, widely held by shareholders? What will Christians do then? And by the way, Ari, I'm an evangelical. I just believe that sometimes we take this so-called religious liberty thing a bit too far when we take it outside our household and want to begin to impose our values on other people. And I think that's where the court got this wrong. Yeah,
I mean, you raise a great point, and you mentioned a specific example of a different faith. This is not a hypothetical. In France, they've dealt with this where you have Muslim adherents who say, well, our belief system is that all women that we come into contact with should have to wear a veil. It's a sincerely held belief, to use the language of the court. But if you strike the balance at saying, well, other people, in this case specifically other women's rights, are going to have to be trammeled in the workplace, that is the quote-unquote balance. It doesn't feel equal. It doesn't feel like a balance, not something that I would recognize as religious pluralism in the United States. I want to bring Burt in specifically to build on this point because Justice Ginsburg cautioned about this, and she wrote in her dissent, the court's determination that the Religious Freedom Restoration Act extends to all of these for-profit corporations is bound to have untoward effects. And referencing this idea of narrowness, she said, although the court attempts to cabin its language to closely held corporations, its logic extends to corporations of any size, public or private.
Well, of course, she's right. What Justice Alito tried to do in claiming this was narrow was a kind of voodoo economics. He said, don't worry, there's no cost here. Absolutely. In fact, he called it zero cost. He said the employees will continue to get exactly the same coverage, and the insurance companies will eat the additional cost. They will be forced to bear the additional cost. And he said, you know what? It's good for them because it's cheaper to insure contraception than it is to pay for the ensuing pregnancy. So what he did with a magic wand is to say, don't worry about this case. It's really narrow because there are zero costs. Now, we're already beginning to see that when you take the program to scale, when you move it from a few religious church organizations and move it to all the small corporations in America, you go from a couple of thousand employees to a couple of million. The insurance companies will simply not sit still for paying that cost. Someone is going to have to pay the cost, and guess who it's going to be? It's going to be you and me, because they're going to demand that they get a subsidy from the United States for the additional costs, and that subsidy will raise an Establishment Clause violation, because what it does is...
And when you say Establishment Clause, what you mean is religious freedom.
Religious freedom. I shouldn't talk jargon. What it does is it forces taxpayers to subsidize somebody else's religious belief.
So let me go to...
not allowed to do that.
Let me go to Goldie on that. I mean, what are the politics here when you have a conservative justice saying, oh, this is fine, the government should just pay for more stuff?
You know, I'll tell you what's happened. The religious right has lost the political, the cultural wars, the politics that they've lobbied over these last 20 years. They've lost that fight. And so now they're casting themselves as libertarians, that, we don't want our rights infringed upon. All the while, they want to infringe on other people's rights. They want, invasive... what are they called?
Vaginal ultrasound?
Yes, vaginal ultrasounds. They want those things to happen. They want to get between a woman and her doctor, and so, rather than cast themselves, as the kind of people who really want to get involved in people's lives, they've respun the argument to say that, hey, look, we're Rand Paul libertarians. We really don't want to be involved in people's lives, and we don't want you involved in ours. They think they're going to win the argument on that measure, but the real politics say that come 2014, later this year, come 2016, you're going to have an awful lot of women, married, single women, Republican women, who are going to vote against those kinds of notions, and I think it's going to cost them.
Well, it's funny you mention that, because I think it also goes to something that Ed talks about a lot on this show, which is when you talk about American business, there is room for business to do good things in our society, surely. But the average voter, whatever their politics, relates to business more as an employee than as a business owner or CEO. The math bears that out. And so they've cast this ruling in a certain way and said, oh, well, if you're religious, you'll have more rights at work. No. Not if you're an employee. It doesn't do anything for you. Now, if you run a company, if you're one of the lucky 2%, okay, fine. And so they're going to have to deal with, I think, the politics of that as people go to work and figure out, oh, this might take something from me in my health care plan or other parts of my work, but not give anything to me. And Burt, I want to bring you in again on this idea of what business does, because you filed a brief in this Hobby Lobby case where you said we give certain benefits to corporations and we treat them as different than people, and that's good for business, but we're going down a corporate sameness here that would be a problem if we basically say that they are not accountable and they're not liable for their executives.
really function well in our economy is a wall between the shareholder and the corporation. That means that shareholders can invest and not have to worry that if the corporation goes bust, they'll come after the shareholders.
The people,
It's called limited liability, hugely important. Corporations can own other corporations and create by a shareholder saying, hey, just treat me as the same as the corporation. Why can't we pierce it in the other direction? Why can't a creditor do it? Why can't the IRS do it and say, forget this wall, it's a phony wall?
Yeah, you put that so well, Burt, because either that wall doesn't mean anything, right, or it's one way only for corporate interests, and I think that's a hard place for this court to be, to say we're only with the corporations and never with the employees long term. Again, it takes time, but as people figure that out. Burt Neuborne and Goldie Taylor, thank you both for your expertise tonight.